Welcome to the first edition of Asked and Answered, where we answer some of the most frequently asked questions on the Legalbytes channel. Let's get into it. Hey everyone, welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. So in the last 4 weeks of live streaming the Johnny Depp versus Amber Heard defamation trial, we have been getting a lot of questions from a lot of folks about the trial process and about this case in particular. Some of those questions have been repeated many times over by a lot of people that have the same kind of inquiries. So I figured that I would compile all of them together into one video so that folks can just check out this video in case they have the same question. So if one of these questions ends up coming up in the chat or in a super chat, we can just respond that it is both asked and answered. So question number one is, why is this case in Virginia? People that ask this note that the plaintiff and the defendant are both from California, Los Angeles specifically. And so it's kind of perplexing that this is a case that is actually happening in Virginia of all places. Well, the legal answer to that is that one way to place a particular lawsuit in a certain state is, of course, by going by where the parties live. However, another way of figuring out where a case should be filed is also by looking at where that claim arose. As an example, let's say you have multiple people that are on a road trip in different cars. They get into a car accident. One is from the East Coast, the other one's from the West Coast, and the car accident happens in Texas. Texas is a proper place to file that lawsuit. Now, in this particular case, we have a cause of action of defamation that arises out of an opinion article coming out of the Washington Post. The Washington Post is headquartered in, of course, Northern Virginia, which is why that is where Johnny Depp's team decided to file the lawsuit. Now, there are other strategic reasons why that was better for Johnny Depp to file the lawsuit that have to do with defamation claims and something called anti-SLAPP. Anti-SLAPP is a concept that responds to SLAPP, S-L-A-P-P, which stands for Strategic Lawsuits Against Public Participation. Basically, SLAPP laws or anti-SLAPP laws have to do with a particular state jurisdiction's rules on how somebody can file a particular lawsuit that might impact someone's freedom of speech, freedom to address their government. Lawsuits are actually a form of petitioning the government, so they actually kind of fall within the First Amendment. California has particularly strong and rigorous anti-SLAPP laws. So Johnny Depp's case in California may not have had as much of a chance of getting as far as it did in Virginia because Virginia's anti-SLAPP laws are different and they are considered to be somewhat weaker. Okay, so that's number one. Number two is, why is the trial currently, at the time of recording, on a break? It does feel kind of strange that 4 weeks into a 6-week lawsuit, we suddenly have a week off. It feels like a weird spring break in between, and it feels like it's a total interruption into the momentum of the case. And a lot of people have been wondering what's going to happen to the jury in the process of that week-long break. Basically, to answer this question, the reason why there is a break in this case is not so much to interrupt the flow. We typically actually don't want that in a lawsuit, but rather because the Judge Azcarate, is required to attend what's called a judicial conference. This is something that is mandated by the Commonwealth of Virginia. Don't call it a state because it is technically a state, but they call it a commonwealth. It's kind of weird. Some states are like that. But anyway, I digress. So Judge Azcarate is supposed to attend this conference, and she really had no other way around it, it sounds. So we were required to hold off for about a week in between weeks 4 and 5 of this trial. We will be resuming the trial on Monday, May 16th, and trial will actually begin at 9 a.m. East Coast time as opposed to 10 a.m. East Coast time. So make sure you've got your alarm clock set. Now, another question that people have asked is, when does Amber Heard's countersuit happen? People have recognized that Johnny Depp is the original plaintiff in this case. He brought the claim in the state of Virginia by filing his complaint, and that at some point down the line, Amber Heard also filed some counterclaims that are similar defamation claims against him. So many people want to know, when does she get a chance to put on her case? Well, actually, she's doing it right now. The two causes of action are being played out at the same time because of the fact that it all kind of arises on the same facts, same evidence, the same parties, the same witnesses. So it kind of makes sense to just bring everything out in front of the jury and have the jury answer both questions at the end. So after the closing argument, arguments, after everyone has testified in this case and the closing arguments have been done, the jury goes off to deliberate and they get the questions on whether Johnny wins on his claims and whether Amber wins on her claims. People have also asked, related to that, is it possible for both of them to win? Yes. Is it possible for neither of them to win? Yes. Is it possible for one to win and the other one not to win? Yes. All of those things are theoretically possible. And that's because for both of them, they each have their own claims that they have brought. And so because of that, they have their own burden of proving their own claims. They don't have to disprove the other person's claims, although that certainly helps in any kind of a defendant sort of a case. Even though in this case, Johnny's the plaintiff, he technically is the counter defendant to Amber's claims. But they still have their own burden, each of them, to prove their own claims up to a certain point. Number 4 on my list is what happened to the metadata issue of Amber Heard's photos. So if you don't know, just before trial began, there was one last motion for sanctions filed by Johnny Depp related to some photos that were supposed to be handed over by Amber Heard over to Johnny's team to have a forensic analysis done. Now, there have been a lot of motions between the parties. This has been a particularly vigorous litigation leading up to this trial. So the fact that there was a motion for sanctions right before is typically, I would say, not really something that you would see at that stage. But given how much litigation and how many motions have been filed and how contentious, I should say, this litigation has been, it is, I guess, not that surprising in that particular context. Now, in that motion for sanctions, Johnny's team basically said, well, you know, Amber was supposed to hand over some photos to us at the end of November, everything from her cell phone for things like text messages, photos, anything that was on her phone that was pertinent to this case. She had until like late November. By early March, she still hadn't handed in the stuff. And then at some point she had handed in some stuff, but the stuff that she handed over was all gobbledygook. Like it's like the metadata on it just didn't make sense according to the forensic expert that was trying to analyze it for Johnny's team. And then on top of that, not everything had been provided. So by the time that this particular motion for sanctions was filed, it was like late March already, like a week before trial was set to begin. Now, as a result, Johnny's team was asking for 3 different types of potential remedies. The first one was just monetary sanctions for the cost of everything. The second one was to allow the photos to come in as evidence, but to allow Johnny's team to comment up and down about this whole metadata issue in front of the jury. Someone is here. I might have to get that door. And the third one, let me get the third one first. That's Indy. I'm going to get the door. Okay. And I'm back. And the third possible thing that they asked for was for the judge to just not admit the photos at all. Now, arguably, the second one was probably going to be the most beneficial to Johnny's case because then they would be able to show the photos that Amber has and to basically call her bluff on all of them. Now, we don't actually know exactly what the judge ultimately decided, but based on what we've seen so far in this case, in the opening statement, Johnny Depp's attorneys started to talk about this metadata issue, which seems to suggest that the court probably allowed that second remedy in this case from the motion for sanctions to come forward. And this is further confirmed by Amber Heard's direct examination this past week, where her attorney was able to admit several photos that seemed to come from her phone. So looking ahead to her cross-examination, presumably by Camille Vasquez, since she's the one that's been objecting during Amber's direct examination, I would anticipate that there's going to be some sort of questions coming out about the metadata of those photos, or if not, then perhaps we will be seeing some kind of an expert testify on rebuttal for Johnny Depp's team for his case in chief, basically the rebuttal after Amber Heard's case in chief. Number 5 is the judge in this case biased? So although those of us on the panel on my channel have often disagreed with the rulings by Judge Azcarate, overall, by and large, I think that she's been doing a very good job. And I think all of the other attorneys that have been on the panel have felt very, very similarly. Although there are some calls here and there that I've disagreed with, I think that the ways in which she disagrees are more along the lines of how she defines certain objections. And we just happen to have a disagreement on that. I don't think that if you look at her win-loss record between the teams that she is favoring one side over another. I think that there are just some objections that she tends to favor more than others, and there are some that she defines a little more loosely or a little more narrowly. As an example, she has a tendency to sustain objections that are made on the basis of foundation. Foundation objections pretty much come up where there's a question as to how would we know that this witness would know what they're about to testify to. As an example, if Amber's attorney were to ask her, what did Johnny Depp have for breakfast on December 25th, 2015, she would have to first ask her where she was on that date, where Johnny Depp was on that date, if she, and then somehow place her in the kitchen on that morning, and then somehow place Johnny Depp in the kitchen on that morning and ask if he was eating anything on that day. Or maybe not so much if he was eating, but what he was eating, if she knew it all. Anyhow, there's a way basically that is set to set up a foundation of how she would know what he was eating on that day by taking those steps back to show that she is someone who would know that kind of information because she was there and he was there and she saw him there and they interacted that day and there was food involved and that kind of thing, if that makes sense. But anyway, to answer this question, basically, I don't think that this judge is biased at all. I think that she's been a very fair judge. And actually, we haven't really even noticed that much about her, which is typically a very, very good sign. It means that she's really kind of being a little bit more of an invisible hand kind of moving this process forward. And that means that she's also not really signaling anything to the jury one way or another as to how they might want to start leaning just because of how she might be leaning. And that's something that any judge in the American judicial system is going to want to try to avoid because they don't want to be subliminally influencing the jury one way or another through their actions or their tone or their behavior. And I think that in particular, Judge Azcarate has done a very good job of being as neutral as possible. Number 6 on my list is the jury sequestered? So sequestration of a jury happens when basically the jury is cut off from the entire world. They're put into a hotel, they've got security, they've got all this kind of stuff to make sure that no one talks to them, they don't talk to anyone, they don't go on the internet, they don't have access to really anything in the outside world. The problem with sequestration is it is a huge, huge burden, not just on the court system financially with all of these resources that have to be used for something like that, but also on the jurors. It can really negatively impact their state of mind. It can impact the way that they see the case overall. And if they ultimately find out which attorney or which side asked for sequestration, that can also bias their ultimate outcome of how they decide in the case as well. Now, a lot of people have asked this question because of the level of public interest in this matter. However, even in cases that have a lot of public interest, they've got cameras in the courtroom, they've got folks like us that are live streaming the trial and commenting on it. Even in those kinds of cases, having sequestration of a jury is really, really rare because of all the reasons that I just talked about. However, there are other ways that the court can take precautions to ensure the anonymity of these jurors while they are in the process of observing trial and then ultimately deliberating on the final verdict. As an example, I would anticipate that what's happening is that they are meeting in some offsite undisclosed location and somehow getting bussed into the courthouse so that no one sees them, no one knows who they are, other than the people that are sitting there in the courtroom that can see them for themselves, but no one is able to record them or follow them or anything like that because running the risk of any kind of juror intimidation, juror influence could be grounds for a mistrial. And so my anticipation is that the court is taking all kinds of other precautions to ensure that none of that kind of stuff happens. Number 7 is, do Amber Heard's attorneys believe her? I have to say, without talking to them, I have no idea. They might believe her, they might not. The thing is, as an attorney, it's not exactly necessary for you to believe your client is telling the truth to support them. I have talked to many a criminal defense attorney who fully understands that their client probably did the thing that they were accused of doing. However, they still want to represent them because they want to ensure that they are given the same due process rights as anyone else should be deserving, regardless of whether they are guilty or innocent. The same thing should be the case here as well. Even though it's not a criminal trial, it is a civil trial. And so the ultimate question here isn't so much whether her attorneys believe in her story or believe that she's telling the truth, but rather if they believe that they can set aside whatever kind of personal feelings they may or may not have about this case and zealously advocate for their client to ensure that she is given all the same due process rights that anybody else would have, and that she has proper legal representation in a lawsuit of this caliber. Any litigator out there knows that you can have a client that walks in that doesn't have the best facts, and your job is ultimately to take those facts and make your best argument that you can make. So for me, that's what I believe that her attorneys here are doing. Number 8 is, can Amber Heard go to jail after this? Well, anyone can technically go to jail because of something that they may or may not have done at some point. But I think that what people are getting at here is whether or not someone might be going to jail as a result of this litigation. And the answer to that is no. This is a civil trial. It's about money. It's not about whether or not someone is going to be incarcerated. That would be a criminal trial. Now, related to that jail question is this question of whether she can be jailed specifically for perjury. And so that is something that I think is also theoretically possible, but in all likelihood not going to happen. So perjury happens when somebody lies under oath. And realistically, the chances of catching someone on something like perjury are incredibly low. Number one, we don't really know what is going on inside the brain of someone. Someone might think that what they're saying is the total truth. And then, in fact, someone else finds it differently. Now, as a policy matter, we don't want to automatically jail the losers of every civil lawsuit just because a jury didn't believe them. So the burden of proving perjury is actually relatively high. It has to be a very, very big lie, and it has to be demonstrably false. Now, I know a lot of people that are viewers of this trial would like to say that her claims are demonstrably false. I think that a lot of what she said is probably demonstrably false, but even still, even with the level of the claims that we are talking about and the amount of evidence that we are talking about that supports Johnny's side over Amber's side, I still think that even if Amber Heard loses this trial, she is very, very, very unlikely to see any kind of perjury charges, at least in the American judicial system. I know that there has been a lawsuit in the UK. I know that there has been legal action in Australia about the immigration issue with their dogs around the time of the Australia incident in March 2015. So I know that there are issues there. I can't comment on either of those two legal systems, at least not much, because I'm not licensed there. And I'm not as familiar with those systems either, other than that they are similar to the United States, given that there's a common history with being part of the United Kingdom and all that kind of stuff at one point. Number 9 is, what is impeachment? So I talked about perjury, lying on the stand, that kind of thing. People have had a lot of questions about impeachment. What is it? What are the consequences of it? What exactly does it mean when somebody says that a witness has been impeached? Now, usually when people hear the term impeachment, I think most people think of an elected official being impeached and then being removed from office. So there's nothing like that that's going on in a civil trial or a criminal trial. Basically, what happens is you have a witness that's on the stand, that they are testifying while they're on the stand to one thing, saying that at 9 a.m., the light was green. Then before they've gotten to trial, what has happened in a lot of cases is there have been depositions that have been made where that witness has already testified under oath, and they've testified to all kinds of things. And so basically, at the point that this witness gets up on the stand in court, the attorneys involved in this case basically know more or less what that witness is expected to testify to, because they've already talked to them, they've already interviewed them, they've already deposed them. Or in a lot of cases, they have signed some kind of a declaration, some kind of a witness statement. In this particular case, there's also some additional testimony that has come out that was in the UK, having to do with the trial by Johnny Depp against the publishers for The Sun. So there are a lot of prior statements that have been made by a lot of these witnesses. Now, all of those statements can be used to impeach the witness. Basically, all that means is to show that the witness right now, right in front of this jury, is not being entirely honest or accurate in what it is that they are saying. Now, even though all of the statements that I just pointed to were all statements that are basically made under oath, it's not actually a requirement for the statement to be made under oath in order for it to be used to impeach. As an example, in this particular case, Amber Heard has made statements in the past on TV shows about the $7 million that she says that she donated to the ACLU and to the Children's Hospital of Los Angeles. Although the $7 million has not yet come up in her direct testimony because of the fact that she hasn't finished her direct examination, I anticipate that there's going to be some kind of a little bit of a twist in her testimony on the stand in front of the jury when the trial resumes again. Now, if that's the case, if she says that she has not yet donated all the $7 million, then Johnny Depp's team can actually use some of those prior recordings from TV shows, where she said that she actually did donate the $7 million. And that is basically just to show that at some point along the line, she has been inconsistent in the way that she has presented herself and presented her case in the world or in this particular case. So just because a witness has been impeached on a particular statement doesn't mean that all of their testimony gets struck from the record. And in fact, even if there is an objection and there's some kind of an objection that's been sustained by the judge, even then, it's not necessarily the case that a statement or a portion of someone's testimony is going to be struck from the record unless there's been a specific instruction by the judge on that. So basically, to kind of wrap that all up, an impeachment of a witness pretty much just means that they are shown by one of the attorneys that something that they said in front of the jury today is not exactly the same as what they have said elsewhere to other people. And it is just basically intended to show that this person has not exactly been honest or credible or accurate at all times on this matter. Number 10 is, can Johnny Depp sue Amber Heard for domestic violence? Number 1, typically that is going to be a criminal case that is going to be brought by some kind of a prosecutor. And there are statute of limitations issues on that. I believe in California, the statute of limitations is 3 years. In other places, it might be more, might be less, but even still, right now, what we are talking about is the last instance that Johnny can say that he suffered domestic violence at the hands of Amber Heard was 2016. That is already going to be about 6 years ago at this point. So we are going to be outside of any kind of statute of limitations for that in any kind of a case. Even if there were some kind of a civil case that could be made out of that, it wouldn't be so much of a DV claim. It would probably be a personal injury claim. But yeah, we're outside of the statute of limitations on any kind of a case for DV by Johnny Depp against Amber Heard. And anytime there's a statute of limitations issue, that is pretty much a hard stop for litigation. That is one of the easiest ways to throw out any kind of a case as a defendant, that if someone has missed their statute of limitations, there is no arguing around it. Number 11 on my list is, can the UK case be retried if Johnny Depp wins this one? Now, this one I have probably the weakest answer out of all of these because, as I mentioned before, I'm an American attorney. I'm licensed in California and DC. I am not licensed in the UK anywhere. So I don't exactly know how their system works. However, if it does work like the United States does, you can't just retry a claim just because elsewhere it has worked out differently for you. Once you have fully litigated a claim within a particular jurisdiction in the United States, retrying it, you're going to have a pretty hard argument against you. And it has to do with something called collateral estoppel or res judicata, basically claim preclusion or issue preclusion, where it's an equitable argument by the courts where basically the idea of it is we don't want the courts to be perpetually involved in the same litigation over and over again. Once you've shot your shot, that's it. If you lost, you lost. And so you've got to move on and try on some other claim maybe, but not on this one. Number 12 is, will Amber Heard's legal team suffer a bad reputation because of this case? I don't think so. Because at the end of the day, like I said before, any kind of a lawyer or law firm with any kind of set of facts, when they agree to take on a particular case, what they're going to do is they're going to take the body of facts that they see in front of them and make their best argument. Sometimes that's a winner, sometimes that's a loser. In this kind of a case, as critical as we have been on various parts of some of the lawyering in this case, I think that there is a lot to be said for the fact that these are attorneys that are working very long hours, and working a very, very difficult case. Those of us who are commenting on it have the luxury of being able to sit back and comment on what should be done, what should not be done, that kind of stuff. But it is so, so, so much harder to be the actual attorney in the ground room right there and actually performing it. It's one thing to say that something should be done, that something could be done, and that this is exactly how I would do it. And it's something entirely different to actually put those words into action. So in the long run, I think that they're going to have a reputation of attorneys that took on a very tough case and made the most of it, regardless of, how they ended up performing, regardless of who ends up winning. I think that ultimately they all will have things that they have learned through this entire trial process that they will be able to put forward in all of their litigation practices. Number 13 is, can the Milani makeup issue come in? So if you're not aware, the Milani makeup issue is this. In her opening statement, Elaine Bredehoft of Amber Heard's legal team held up a particular compact by this company called Milani, and she said, this is the makeup that Amber Heard used throughout her relationship to cover up her bruises. What came out since then was the company that actually makes that product came out and said, actually, that's impossible because that particular compact only came out in 2017. It's absolutely impossible that she used that compact throughout her relationship with Johnny Depp because they divorced in 2016. So, of course, people want to know, can this information be used at trial? Now, as an initial matter, my first thought, of course, as an attorney is, well, this particular compact that is being held up right now by Elaine Bredehoft may not have been in existence before 2017, but is there a similar one that the 2017 compact replaced that basically was essentially the same thing, but maybe just a different model, maybe a slightly different formula, but essentially is the same thing? If that's the case, then I think that the idea that this one wasn't created until 2017 is not as strong of an argument as it may seem, particularly with the proliferation of the TikTok video that Milani came out with in order to explain that whole thing. But even if it's the case that there was not a compact that kind of was a predecessor to the 2017 compact, there's a limited number of ways in which that can come in. And one reason for that is that the two parties involved in this case have to exchange their evidence ahead of trial. One of those ways is by producing what is called an exhibit list. They have to produce a witness list and an exhibit list so that they can show and put the other party on notice for what kind of exhibits that they plan to use, what kind of witnesses they plan to put on the stand to testify. Now, it is true that Amber Heard's attorneys have placed on their exhibit list some kind of a makeup palette. Now, it's not exactly clear what kind of a makeup palette that is, if that is the Milani palette, if it is the particular Milani palette that Elaine Bredehoft was showing during the opening statements. However, it is interesting that makeup palette has been reserved by Amber Heard's team to introduce into evidence. Now, just because it is on the exhibit list doesn't mean that it has to be used, and it doesn't mean that it has already been admitted into evidence. So there's a chance that Amber Heard's team could decide not to admit that now that they know what they know about the Milani compact. But there's a possibility that it might still come in at some point. Now, people have also asked whether Johnny Depp's team can enter this into evidence or somehow bring up this issue of the compact being created in 2017. And my answer to that is maybe. See, the issue of makeup has come up quite a bit in this trial. Elaine Bredehoft seems to be the one that wants to ask every single witness in this trial whether they noticed if Amber Heard was wearing makeup when they saw her. So it wouldn't be unfair at all if on cross-examination, Camille Vasquez asked Amber Heard about her makeup and asked her what type of makeup she used and asked her what brand and asked her exactly what kind of a palette she used. She could even identify a model of or a copy of that particular palette that Elaine Bredehoft showed to the jury in their opening statement, and to ask her if that is the makeup palette that she in fact used throughout her relationship with them. The thing about that is that Amber would then be put into a position where she would either have to say no and show that her attorney was maybe misrepresenting things to the jury in her opening statement, or she would have to say yes, and that could bring in the information from Milani about the 2017 makeup palette, which would then be used for impeachment. And that's because that is one of the exceptions to the rule for the requirement to exchange evidence ahead of time. If there is some sort of evidence that is required to rebut a particular claim or to impeach on a particular claim or impeach on a particular statement, that is one of those exceptions where they actually don't need to produce that ahead of time. They can actually introduce that potentially introduce that at the time of impeachment. All eyes on Camille Vasquez once again for this cross-examination. We will see what happens, but it'll be very interesting to see if she's able to work that into the cross-examination along with all of the other potential areas that she has that are pretty fertile areas for cross-examination. Number 14 is, did Amber Heard snort something through a tissue while she was on the stand on direct examination last week? Yes, I have seen the clips showing something about her wiping her nose with a tissue, stopping, perhaps inhaling something. Maybe, I don't know. The thing is, she also is under the world's tiniest microscope, or the world's most fine microscope, I should say. So she very much understands that there are a lot of people and a lot of cameras and a lot of attention on her in the moment that she is particularly on the witness stand. She's got the jury looking at her. She's got the judge, all the attorneys, and all the cameras on her in that particular moment. So people have asked about whether that might be cocaine that she was snorting on the stand. I highly doubt that she would be doing that right there on the stand. People have also asked about maybe it was some sort of mineral oils or essential oils to make her cry or something like that. Maybe possible, I guess. She also could have just had some snot in her nose and just decided to try to clear her nose in one way or another. For me personally, this one is a little bit less of a pertinent issue than the actual substance of her testimony. It's kind of interesting to watch. It's kind of strange to watch. There's been a number of strange things that I guess she's done on the stand. But for me, this is a little bit less of something that I think warrants attention than the actual substance of her testimony itself. Number 15 is, can the clip of Amber Heard posing for a photo be played for the jury in closing arguments? My answer to that is probably not. See, typically what'll happen in closing arguments is the attorneys will get up and they will sum up all of the testimony and all of the evidence that the jury themselves have seen. However, the jury has also been paying attention, ostensibly, the entire trial, and they've been watching all of these witnesses. They've been taking notes. They've been making their own observations. They don't need to see testimony replayed a second time, or even parts of a witness's presence on the witness stand, even if they weren't testifying at that time. The idea is, if the jury did not notice something while that person was on the stand, then they didn't notice it. You know, I've said this many times that you can have a lightning round of cross-examination where the attorney gets out the world's best information out of that witness for their case. But if the jury is counting the number of tiles on the ceiling because they're bored to death, they're not paying attention. And it's this similar kind of metaphor as, you know, if a tree falls in the woods, doesn't really make a sound if there's no one really around. Similar to that, you know, if the world's best evidence comes out in front of the jury, but the jury's not paying attention, does that evidence really come out at trial? I don't know. They're going to miss some stuff from time to time. There's only so much attention that they can pay throughout these long trial days. And aside from that, whether they can play a clip of her posing for a camera with a tissue, that's really way less relevant or pertinent to this particular case than, say, debunking the claim that Johnny Depp broke the bed because of how violent he was, you know, beating her up on December 15th, 2015, or, you know, debunking the claim that he also trashed the penthouse apartment on May 21st, 2016 on his way out because the police came by an hour or 2 hours later and saw absolutely no trashed anything, no wine stains, no glass that was broken, no nothing. Those are the kinds of things that are way more important for Johnny's attorneys to be focusing on in their closing argument. And so, you know, things like that that were, kind of focusing back on the little microscopic things that Amber might be doing that are kind of strange here and there, those are going to be way, way, way less worth their time. They're going to want to go for the higher impact points to turn into their closing argument. And finally, number 16 I have here is, why was Ben Chew excited when Amber Heard brought up Kate Moss? So when Amber Heard was on the witness stand in her direct examination on Thursday, she mentioned she was talking about when she was at the top of the stairs at the penthouse, her and Whitney and Johnny. And she talks about how she was trying to protect her sister Whitney from Johnny somehow. And she mentions how into her mind came an image or the idea of Kate Moss and the stairs. And that was ostensibly to imply that there was some sort of an allegation against Johnny Depp that Kate Moss was somehow either tossed down some stairs or beaten up around some stairs. Basically, that there was some sort of violence by Johnny Depp against Kate Moss having to do with stairs. So the reason why Ben Chew and the whole legal team could potentially be excited about that is because they have been saying throughout this trial that no one in Johnny's previous relationships has ever accused him of domestic violence. That includes Kate Moss, one of his former partners. Now, the thing is, as a default matter, Johnny can't just bring in all of his ex-girlfriends and ex-partners and have them testify to how great of a person he is and how they've never had an issue with him. The reason for that is because that would be called what we would call propensity evidence, basically saying that because someone has had a tendency in the past to be like X, they couldn't possibly be like Y in this kind of a situation. It's basically using a broad trend to try to apply it to a very minute circumstance. And the reason why that's not allowed is because it's kind of logically inaccurate. Someone can have been a total pacifist their entire life and then suddenly break and become very violent in a particular instance if they've been moved to some sort of a breaking point, or if certain circumstances in their life have changed. There are a lot of ways that that can sort of transpire. Someone who is peaceful throughout their life can be violent. It is totally possible for any of us to stop following the rules of society at some point. So generally speaking, we don't allow that kind of propensity evidence by previous partners to come in a case like this. But now what has happened is Amber Heard has kind of made that into a separate issue by referring back to her and basically implying that he has been violent with one of his previous partners. And by testifying to that, she essentially is saying he actually has prior bad acts. He has maybe this tendency to be violent. And so because she has been the first one to testify to something along those lines, she has actually done what's called opening the door. She's opened the door for Johnny to allow in these prior partners to testify exactly to the opposite. And particularly in this case, because she referenced Kate Moss, that would allow Kate Moss to come to the stand as a rebuttal witness. So the way that I interpret that is that now Amber Heard has just opened the door to allow Kate Moss to come in after Amber has already closed her testimony and closed her entire case in chief. Johnny's able to bring in rebuttal witnesses to respond to some of the testimony, and Kate Moss can totally come forward. Apparently, she's made statements to the public about Johnny Depp from her relationship, saying he has always been the best person. He's never been violent. He's always been wonderful. So I would expect her to be totally willing to come in person and to testify to all of that. And if that's the case, that is so damaging to Amber. And that is what we would call an unforced error. She didn't have to bring up Kate Moss. No one asked her about it. She was the one that volunteered her name. And so by invoking her name, she may have driven in what could be one extra nail in the coffin of her case. Anyway, that's all the questions that I have for now. But at some point, maybe I'll have to do an asked and answered part 2. If you have any further questions, let us know in the comments down below. Is there anything here that surprised you? let us know about that as well. Otherwise, I hope you found this interesting or at least informative. And if you did, I would love it if you'd hit the like button. It does help us with the YouTube algorithm gods. And otherwise, if you haven't done so already, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded and so you can join us during the next live stream of this trial, May 16th, 2022, starting at 9 a.m. East Coast time is the trial. I'll start our live stream about 30 minutes before then so we can get kind of warmed up, get excited, get talking about the case. It's a lot of fun. You might want to join. Anyway, see you in the next video.